Good evening, welcome to our Open Rights Group EU digital debate. This comes just 7 days before the start of European elections, and the reason why we put on these debates, we put on 6 around the country, is that so many of the issues that we campaign about, and digital rights issues, are now decided or debated at European level. So it's crucial that we have the right MEPs who are going to stand up for our digital rights. I'd like to thank Glyn Moody for agreeing to host this evening, and I'll pass over to Glyn in a second. We have a hashtag of #EU Digital Debate, and there'll be discussion and questions going on there. If you want to submit a question that way, you can, but we'll have hands up as well, so that's fine. And at the end, we have several people who have supported us, and I'll talk about those right at the end. So I'll just pass over to Glyn, and pass on my thanks also to the candidates who turned up. Just a word, that empty seat on the end there is for the UK candidate who hasn't turned up yet. So maybe we'll have someone joining us in a second. Glyn.
Okay, thanks a lot. Good evening, ladies and gentlemen. Thanks a lot for coming along, and thanks particularly to the panel that's given up their valuable campaigning time to be with us this evening. So this is really your opportunity to ask all those questions you've been dying to ask. So it's very much for the floor to ask the questions, but the structure will be as follows. It will be based on sort of topics. I'll ask a couple of questions around that topic of each of the panellists, and then I'll throw it open for yourselves or the people who are online, if they want to send through by Twitter or email or any other known means. So on that basis, I'd like to start off with a very easy question by asking people to say who they are and who they represent, and if they want to make a very short speech about anything to do with the issues we're going to talk about, that's fine, as long as it's not too long. Thank you very much. Just say who you are.
I don't want to start first, but I will. My name is Claude Moraes. I'm the Labour candidate on the panel. Just to say, well, I've said it. What else do you want? Just a quick statement.
A quick statement about.
Well, first of all, I'm really happy to be here. I think, first of all, to organise this, and just to correct one thing that Glyn said. He said giving up our valuable time from our campaign. This is now a central issue of our campaign, and I think that's the difference between the last election and this one. I think digital rights have finally arrived as a key election issue, and I think we've helped make that the issue, and also the issue of the balance between our security and our freedoms in the digital era. And I think people in this room and people who have contributed to the organisation have helped make it that way. So I hope this evening we can have a discussion about how we've taken various positions and balances on some of the key issues that the European Union has touched in this area.
I stand corrected, you're absolutely right. It is absolutely central. Please, Julie.
Thanks, Glyn. I'm Sarah Ludford. I'm the lead candidate for the Liberal Democrats. I'm a sitting Lib Dem MEP Lib Dem MEP for London, and I'm proud of the record that we have both domestically and at European level. We vetoed in national government the Data Communications Bill, or the so-called Snoopers Charter. Nick Clegg has set up an independent review of state surveillance and the legal framework and oversight for that, without, I'm afraid, the support of the Tories, so it has to be outside government. We passed a digital bill of rights at our party conference in spring. And at European level, I'm delighted that the European Court has struck down the Data Retention Directive, because we opposed it from the beginning in 2005, and I was there to vote against it. We have led, I think, on the principle of net neutrality, which has been enshrined in the Parliament's position on the telecoms package recently, and I believe that we played a major role in getting a good text on the Parliament's position on data protection regulation. So I'm proud of all those things nationally and at European level.
Thank you very much, Danny.
Hi, my name is Danny Bates. I'm one of the Green candidates. Jean Lambert, the Green MEP, can't be with us tonight. She sends her apologies. Just to say a couple of things about what we're working on Parliament. Greens have 58 MEPs in the European Parliament. That makes them the 4th largest group. That's larger than the Conservative group and larger than the UKIP group in the European Parliament. Because the elections are a proportional election, I think if you vote Green in the European elections, you will potentially return a Green MEP for London. In terms of the issues, Jan Albrecht is a German Green MEP who is our spokesperson on digital rights, and he's led the way being the rapporteur on the data protection regulation, and pushing very hard for that. Basically, we see digital rights as an increasingly important issue, a core issue really, and we have a manifesto commitment to include a bill for digital rights, which would include the protection of privacy, the protection of personal data, and the guarantee of net neutrality. I'm sure we'll go into these issues in more detail. We think the time's right for an EU cloud, and we feel that there needs to be a lot more protection against e-surveillance. We spoke out very strongly about Snowden and called for the EU to give him protection. Unfortunately, that wasn't protected by that wasn't supported by the other parties, so we weren't able to get that agreed at the European Parliament.
Okay, thanks very much. Okay, already we've had the word surveillance mentioned several times, and I think a lot of people here will be quite keen to talk about that. So I'd like to begin with that area, please. We're in London, which is famous for having more CCTVs than like anywhere else in the world. We've learned recently, or last year, that basically the entire internet input and output is being ingested by GCHQ. So surveillance is actually pervasive in this country. I'd like people to just comment on what they think about these revelations of Mr. Snowden, and indeed about the general levels of surveillance in this country, and to comment what might be done at the European level. And since I started with Claude first, I'll start with Sarah. No, I'm going to change it every time, to be fair.
I think the European level has got some role to play. Of course, Claude was the author, rapporteur in our jargon, of a very significant investigation and report that we passed just before we went into recess. I think most of the work, obviously intelligence is not as such an EU matter, so a lot of the work around oversight and legal framework has to be done at the national level. I have been quite honestly gobsmacked at the lack of outrage and debate at the national level in the UK. And so I am very pleased, and I mentioned this in my opening remarks, that Nick Clegg, as Deputy Prime Minister, has commissioned an expert panel under the aegis of the Royal United Services Institute to look into the oversight and legal framework. I mean, to be honest, it seems pretty clear to me that RIPA is inadequate, and even more glaringly clear that the Intelligence and Security Committee is completely inadequate. I think one obvious conclusion, it needs to be chaired by an opposition politician and needs to be thoroughly independent to report to Parliament, needs to be able to call the spooks to account and not be, if you like, sort of too cosy with them. I think the EU main role is to work on a transatlantic basis, and a lot of the suggestions for that were in Claude's report, so maybe leave him to major on that. When we did our text of the data protection regulation, one of the things we put into that was the so-called anti-FISA clause that the Commission had left out of its published proposal. And that says that companies cannot obey foreign court orders like the FISA court unless it's in the context of an international agreement, for instance, mutual legal assistance. So we're asserting European jurisdiction, as is also the case in the court judgment this week about Google. We're saying that if it's Europeans' data, it's got to be European rules that apply to that data, and it's setting up a need for transatlantic discussions.
Okay, great. Danny, would you like to give the Green perspective on these, please?
Yes, I mean, obviously the revelations, the e-surveillance revelations have been very, very shocking, and of course one of the things we need to take fully on board is that the UK authorities were very involved in that too, and the Tempora programme, comparable to the PRISM programme, initiated under Labour using the RIPA legislation, which was Labour legislation, I believe, and of course continued by the coalition, so that really does need looking at. There is a role for the EU, absolutely, and has already been said. The protection of EU citizens' data has to be a crucial element of that. The challenge, I think, is getting a robust legislation agreed, and getting that legislation agreed by the Council of Ministers, because contrary to some of the perspectives that are given, it will be the Council of Ministers that will have a very strong voice in that, and it may be that they don't give the level of protection that is needed. So I think one of the things, as campaigners as well as legislators, one of the things that needs to happen is pressure on member states as well to protect citizens' data, and that involves people writing to their MPs, putting pressure on the government, as well as working through their MEPs to bring about that change that we need.
Okay, thank you very much. Sarah mentioned that Claude was the rapporteur on an extremely important working group on this very subject, and I'd like to salute the work that he's done on that, because it seems to me that in a very short time he put together a really fantastic report and a very hard-hitting report. I was really impressed. I thought we were going to get a little bit of a weak, well, this wasn't a very nice thing to do, but it was really hard-hitting, so I'd like to congratulate you on that and ask you for your thoughts in the wake of that report.
I think the first thing to say is that they got a very wide political agreement in the end, which I think is significant for the European Parliament. And one of the reasons for that is that a lot of work has been done by wider NGOs, think tanks, civil society in this area. We were fortunate, timing-wise, following the Snowden allegations, to be in a position where we filled a gap. The Snowden allegations happened. We were coincidentally pursuing the biggest international privacy legislation, the Data Protection Regulation, and then the directive. So we were in a position where it was the moment where we needed to investigate exactly what was happening in relation to both his allegations, but also this whole area and the balance between freedom and security in this whole area. And it had not really been communicated to many of the people who looked to us for answers. Sarah rightly talked about the Data Retention Directive as an example of where a rush to legislation, and indeed my party and the Conservatives had rushed to that legislation where it was struck down by the European Court of Justice, but the judgment was in fact a very good judgment, because it reflected very much what our inquiry was saying, which is that the way to deal with terrorism and security and so on is not through the gathering of bulk data at huge cost in an indiscriminate fashion. And these are the kinds of conclusions that people want us to try and come to in an objective, sensible and balanced way. And I think the inquiry also looked at a whole range of agreements that we have with the US, between us and the United States. Safe Harbour, the SWIFT agreement, PNR, passenger name records, a whole range of things. But on surveillance, which Sarah rightly said is an issue for member states, how our intelligence services work, there's no question it is an issue for member states. We're also acting in the way that all member states act. We are members of the European Parliament, and there were many inquiries all over Europe, some of which took hours to investigate this. And we at least had the objectivity to take some months and to have a proper investigation of these allegations. And I think the conclusions we came to at least had some influence in the territory. And for my party at least, there's a shift in the way that we want to have scrutiny arrangements on our intelligence services. That's absolutely the case for the Liberal Democrats, but there's also a shift in policy going into the next election for my party in the next paper speech on this matter.
So it says that's the UK that wants as well.
That's the UK Labour Party, and it's right for me to come along here and say that today, because it's not a completely foreign policy, but both Ed Miliband's speech and Hugo Young lecture and Yvette Cooper's speech on this subject indicates that we will shift our policy on the matter of surveillance, on the matter of scrutiny of the intelligence services, because it has to be a modernised policy. It can't go on the way that it has so far. The Liberal Democrats have are in the process of modernising their policy on that too. And I think for us that's very important. But what we've done in the European Parliament is critical to this, and I think that's something that we're very proud of doing in an objective way. And as Sarah rightly said, it got wide political support in the end, and I think that's a very important achievement for the Parliament. There's a lot more to it, but I'm not going to bore you with it. There's a lot of aspects that come in other questions that you may ask.
We're going to explore that perhaps in a minute. So I think that's an interesting point, that the European Parliament could well have. Okay, thanks a lot.
Sorry, I'm late.
That's okay. European Parliament could play a very important role at the national level too, in terms of priming the national. I see that Paul Oakley has joined us. Thanks very much. Do you just want to quickly have a quick word about who you are and what you and your party's views on this sort of digital rights issue is? Because since everyone else has had about 2 minutes just on that.
Certainly, very briefly, I'm sorry I'm late. I'm a barrister and I had an urgent matter to deal with. I could either have come here on time or left the geezer in the lurch. I decided to help him out. I am second on the list for European Parliament in London. As far as the digital economy and digital rights are concerned, to be honest with you, I'm not a specialist in any way, shape or form. What I am is a supporter of Big Brother Watch and No to ID, and for this reason I will refuse to have a smartphone, because I do not want sinister agencies in America and elsewhere spying on everything that I do. That's my personal view. I don't particularly know what my party's view on this is, because we don't actually have any technical specialists, but anything which is to do with an invasion of privacy, I'm against it.
Thank you very much. And so, could you say something about sort of what you feel the Snowden revelations about surveillance mean for this country and for the European side of things? Have you got some comments you can make on that?
Yes, it's very frightening indeed. I think that we all have to take notice of the fact that nothing we do online can be considered private. Now, certain members of my party, as you know, when they've come in from the pub, they go onto Twitter and they say things that are close to the knuckle. I wouldn't even do that if I'd had 10 pints of beer. But anything and everything that you put online or that you do online can be spied upon. So I think we're going to see a trend, and it has to be down to the individual. You can't rely on any state organisation, but you are going to have to think very carefully about what you do online and act accordingly. I don't trust any state institution now, to be quite honest with you.
Okay. And before I throw it open to the floor for questions on this topic, we're going to do it by topic and then the floor will take over. I'd just like to ask the panel for their views on Mr. Snowden himself. So, I mean, is he a hero? Is he a traitor? Should we give him asylum? Should we give him a medal? I mean, what should we do with Mr. Snowden?
Hero, absolutely a hero.
Okay. Other people?
Yes, a hero, and as I mentioned earlier, the Greens did call for him to get protection in the EU.
But is that possible? I mean, my understanding is it's not a competence that the EU level to give asylum.
Well, we called on member states.
Okay, so you wanted a member state to give asylum, is that right?
Yeah, there was a proposal to call on member states, and had the Parliament supported that, that would have sent a strong signal to member states for that to happen. And there's other examples of legislation that goes in that way.
Okay. Sarah?
I think he's performed a useful public service. I would wish that there were better whistleblowing arrangements, and actually that's one element in Claude's report, which would have avoided him having to go to China and Russia, not exactly two states known for their openness and lack of surveillance.
Okay, thank you very much. Now, what I'd like to
just say that. Yeah, but quite just quickly, just a big part of our report is about whistleblower protection, because we interviewed Edward Snowden, and the point is that he tried to blow the whistle, but he couldn't, and that's one of the big issues. So, and as a result of his allegations, we were able to do the work that we did, and that's
Okay, sorry.
In fact, I was going to talk about whistleblowing later on, so perhaps we can come back to that. So what I'd like to do now is to throw the floor open for questions on this particular topic. We can try and keep it specific to surveillance-related areas because we've got a lot to get through for the rest of the day. Gentlemen at the front.
Yes, the panel talked about the EU's ruling that you can delete a past, like if you've got a dodgy history, whether you're a company or a person who's a criminal, you can delete your commercials you want from the internet. And also, as you've secretly signed a Trans-Pacific Pact and the mergers, I know this is with surveillance, but it seems to be that the EU goes into corporate fascism.
The transatlantic trade agreement is something I was going to talk about later, so perhaps we could say that, and also the right to be forgotten. So that's really a separate issue to do with privacy, so we will come to that. Hopefully. Are there any questions on surveillance specifically and the Snowden revelations? We'll be linking up, gentlemen about it.
Excellent. Would you support a challenge to the Home Office's position that the UK doesn't need to change its legislation with respect to surveillance?
The question is whether you would support changing the Home Office's position on not needing to change surveillance laws.
I mean, I take your word for it that that is an announced Home Office position. It sounds likely that it is. I think the Liberal Democrats, through the work of Nick Clegg as Deputy Prime Minister, in setting up the independent panel, the review that I mentioned, has indicated that we are not comfortable or content with the status quo. I mean, that would, I guess we'll wait till, we pass this motion to conference on digital bill of rights, opposing blanket mass surveillance, and I can't now remember I've got it somewhere in this pack, but the finer points, but one of the issues that Nick Clegg has asked this independent panel to look at is the legal framework. And I think that shows you that we are not content that the legal framework is sufficient. My own personal view is that RIPA was not good enough when it was passed 12 years ago, 14 years ago, I think. And it has, we've had so many examples of it being used. I mean, there's so many people who can invoke RIPA for even sort of, real-time surveillance, not necessarily online. And I think it is far too lax. As far as I understand, I'm not techie, I don't understand really the history, but I think it comes out of the history, and it was an attempt to actually codify and have statute about these matters, but I think it probably made a legal framework of what had been very informal arrangements before, back from the days when BT, for instance, was state-owned, and there was just a pipeline, I guess, from the intelligence agencies into BT exchanges, as they then were, I suppose. So I think RIPA was way out of date at the time that it was passed, and certainly is now.
Anyone else have a comment on the issue of reining in surveillance?
Yes, I think the legislation is significant overhauling, significant change. In the narrow context, and this is only a narrow context, in the context of spying on elected members, and certainly members of the Parliament, basically the Lords and the Commons, there's a thing called the Wilson Doctrine. I don't know if people are familiar with that, but basically it says that the security services shouldn't spy on elected members. And the Green MP, Caroline Lucas, and the Green Baroness Jones from the Green in the House of Lords are bringing a legal case to challenge the government on this because it does appear that the Wilson Doctrine is being violated, so that's going through a legal process currently. That's just one example, but I think across the board, I think what we need is we need protection of our rights, which is why the importance of of a Bill of Digital Rights is there really, and that needs to be an important focus. And then if we have protections, that's the right way around to do it, rather than assume that we can be surveyed upon.
So would you support a digital Bill of Rights in the European Parliament?
Well, our general view is we will not support anything which expands the power of the European Union. So probably from that philosophical standpoint, no. But we would support a Bill of Rights, if that's what you want to call it, if it was UK only based. And for example, I can think now of Section 5 of the Defamation Act 2013, which allows you to contact ISPs and say, I want my information removed. Going on to the ECJ's more recent discussion about deleting factual information, I'm very much not in favour of that. Subject, of course, to the Rehabilitation of Offenders Act. Certainly people who have had spent convictions should not expect those under that act to have them bandied about over the internet again and again and again. But we can do this at a national level. We don't need to involve the European Union at all.
Okay, thank you. Any other questions?
So it's been mentioned before how the EU doesn't necessarily have jurisdiction over national security, and the Data Protection Act that we currently has an exemption for national security. As Danny mentioned earlier, one thought is that by using something like an EU cloud, we would avoid collection under US surveillance. I think there are, clearly there are flaws with this when we have agreements between the UK and the US, and also when it's absolutely necessary that businesses that operate in the EU have to do trade in the US. And the moment they do that, they fall under US jurisdiction, and as we can see in the recent New York case ruling for the Dublin servers where data was repatriated to the US from there, the moment they're dealing in the US, they have to deal with US law. So how can we create a EU cloud that can deal with the multinational business landscape we have today?
The question is, how can we create an EU cloud that would address some of the problems with surveillance and jurisdiction and privacy? That's going to be
first of all, the EU cloud, there's a lot of discussion between the EU and the US about this. They are concerned that the construction of an EU cloud is a kind of competitive thing, and in the TTIP negotiations, the EU-US trade negotiations, their concern is that there's not any economic value in the construction of such a cloud, but there's economic value in the use of such clouds. So they're getting very concerned about it. But the point is, the real flashpoint is none of that. It's the transfer of business information through Safe Harbour, which just doesn't work. And I think that's the first big building block that just doesn't work. It's a worthless agreement.
So should it go?
It should go, and that's our view. And we differ from the United States on that. And I think that we have been very strong on that in our inquiry report, which is why we feel we were objective. We looked at it very carefully, and that's the first thing we need to sort out, because we're dealing with huge amounts of information of businesses right across Europe being transferred, but we've got US companies signing up to this, and it's just not an agreement that's working. And we have some criticism as well of the Commission and their recommendations, so-called recommendations. So we need to fix that first. But on the cloud, there's a lot of discussion as to whether that's the solution as well. But that is definitely ongoing discussion. I don't know if
Does somebody else want to comment on that idea of the EU cloud?
Well, I certainly want to boost EU cloud capacity, which is subject to EU data protection rules. As Claude knows, and this may be my lack of tech knowledge, I don't really know what an EU cloud is, as opposed to EU cloud capacity. But what I want is for the EU to robustly assert the right of the data of European citizens to be covered by European data protection laws. And that's why this week's court judgment is very helpful in saying that Google cannot wriggle out by saying that it's google.com which operates the search engine. The fact that it's got an established company in Spain means that it does have a presence. Of course, that doesn't address the issue of companies established outside the EU, and the new data protection regulation does address that problem. But Google tried to say that it was not covered, and the court has put a stopper on that. And the court has also said that Google is both a processor, is processing data, and is a controller of the data. And I think those are two important principles, and I know we're going to discuss later the ramifications of the judgment for data protection. But I think so the EU has got to robustly assert our rights, but I don't want balkanisation and fragmentation of the internet. So I want us to try and forge, if you like, a new grand transatlantic bargain. No, maybe that's unrealistic. So we've got to play hardball with the Americans. But I hope, and not least for all the businesses in this part of London, in our constituency, who really want, if you like, a neutral regulatory environment whereby they can choose the best place to put data on cost considerations particularly, without having to decide, well, what exactly the regulatory implications of that. So I would like to try and forge, and that's what the EU has been trying to do with the United States, and I hope that there are encouraging developments, and I hope this judgment this week will also get some clear thinking in Washington as well.
Just on the trade negotiations dimension of this, I mean the Greens are opposed to the EU-US trade agreement, TTIP, the Transatlantic Trade and Investment Partnership. There's a publication I've also copies along at the back. People who are interested in this to find out a bit more about why the trade agreement is, in our view, a very bad idea between the EU and the US. Labour and the Lib Dems support, as far as I'm aware, support and vote for that. The Greens voted against that in May 2013 when it was proposed, and have tried to propose it further in the European Parliament. The cloud issue is relevant to that, but there are lots of other issues why TTIP is bad, so that's something to take into account. In terms of what the core issue here is, though, I think it is about the protection of the data, and the argument that the EU cloud is of value is because there will be more control over that data if it were located in the EU, but the control of the jurisdiction is the key issue. And of course, if a large number of these companies are US-based companies with data stored in the US, at least your starting point would be that there will be, less de facto protections for EU citizens unless there can be significant larger assurances. And given that the EU has a population of 500 million people and large corporations across the world want access to that market, I think the EU is in a very strong place to say, well, actually, we want the rules that are going to change somewhat. So that's something I think we need to look at very closely, and just to take the perspective of the rights of EU citizens more as the core. Really.
Paul, views?
Just so I'm clear about the terminology, by EU cloud, do you mean a non-PC storage system like any other cloud? Is that what we're talking about?
So part of the issue is that there is no clear definition of what an EU cloud is. Before we have operators that are EU companies that privately operate clouds within the EU. We have international companies that operate clouds where they say that they will store your data in the EU, but they're international companies covered by jurisdictions wherever they operate. So even if it's in the EU physically, it's still covered by other jurisdictions. So I'm not sure when Vivian Redding or Daniel Harris MEPs refer to an EU cloud, it's never been clear what an EU cloud would actually
Exactly.
It's true. That's
Well,
My point
having clarified that, quite frankly, anybody who uses a cloud of any kind is absolutely mad. Hard drives are extremely cheap. I wouldn't dream of using that. So, from that point of view, I'm not really interested in any way what the EU chooses to do.
Okay. Question here.
Hi, am I on? I am now. Jane Callion from PC Pro. Coming back to your point, Sarah, about playing hardball with the Americans, is this something that's actually really rather hard to do given that they hold cards? We only have to look at Microsoft, or really the US called Microsoft a couple of weeks back, that data held in the Dublin data centre is still accessible under American law, despite safe harbour, despite everything. So we can talk a lot about playing hardball and about the fact that people want access to our market, which I'm sure they do, undoubtedly. How do we play against that, given that they largely hold all the cards?
Well, I'm not sure they do hold all the cards. I mean, as Danny actually said, we've got a market of 500 million consumers, and all the US tech giants want access to that, and it will be a tough negotiation. I mean, I think the Parliament supports the position that data protection should not be part of the TTIP negotiations, but parallel to TTIP, there has to be some extremely active and energetic negotiations on what the overriding data protection umbrella is going to be. As I say, I don't think that the Americans do hold all the cards. I think it's going to be a very tough situation. I mean, look at the way that the Microsoft and Google and so on, they are, to the extent that Obama is talking about a change in surveillance law and oversight in the US, a considerable part of that shift is due to the tech companies saying we are losing business in Europe over this. So I don't think it's cut and dried at all. It does. I think it requires a very, as I say, robust European response, but not one. I want interdependence. I'm not terribly signed up to Vivian Redding's declaration of independence, because I don't think that's terribly helpful to business or to citizens, to be honest. But I do think that we have got to assert our jurisdictional space. That is going to clash with the American assertion of jurisdictional space. But conflicts of jurisdiction are what international negotiations are set up to try and sort out.
Okay, thank you. Could we move on just a minute? Because several other people want to ask questions.
Yes, I have a question which Dan has already touched upon. Is the question of Snowden and his revelation. I'd like to ask each of the panellists whether they would support giving Edward Snowden asylum in this country.
We did actually address that earlier.
I don't think you have.
Yeah.
You haven't addressed that particular issue. I'd like to ask each of the panellists whether they would support granting Edward Snowden
Where?
asylum in this country.
In the UK?
Yes.
Okay.
I'm happy to answer.
Yeah, please. It should be on.
Without question. Is this thing on? Yeah, it is on now. Yes, without question, the whole reason for seeking asylum is if you face a well-founded fear of persecution. He ticks that box. No problem at all.
Broadly, yes. And I say broadly yes because there's more than one way to get protection, and it's a bit of a boring technical answer. Sorry about that, but it's possible to give protection without giving full asylum rights. So, looking at that issue in some detail, the Greens in the European Parliament concluded that it was more appropriate to go down that route. So yes, protection with all the things that follow from that, but technically not asylum. But yes, certainly we would do that, and we've urged the UK to do that, and other EU member states too.
Well, I think he's very welcome to apply, but I couldn't adjudicate on that any more than I can adjudicate on any other asylum.
I'm not asking you to adjudicate, I'm just asking whether you would support rising.
No, I don't. I mean, I have people who write to me and say, will you support my asylum claim? I say, that's not my job. My job is to make sure the relevant authorities fairly determine your claim. As a parliamentarian, I don't decide on asylum claims. And I wouldn't be able to decide on Edward Snowden's any more than somebody who applies to me. I do have people, I'm sure all MEPs do, who say, will you support my asylum claim? I don't know the detail. I'm not set up to determine the detail of what's happened to them or the law or whatever. So, sorry not to be able to give you that simplistic answer, but it happens to be the fact and the law.
Well, we did interview for our inquiry, and we didn't show too much enthusiasm for applying for asylum. You know, it's Germany perhaps, but not the United Kingdom.
Thank you. There's a gentleman there and then a lady there. Could you pass the microphone, please? Just here at the front. And after these two questions, perhaps we can move on a little bit because we've spent a good while on this.
Yeah, I think just going back to the issue of the European cloud, I mean, ultimately, while we have something like the US Patriot Act, the European cloud would have to be an infrastructure that is free from any kind of influence from any American-based company. And I think it's almost inevitable that an EU cloud will create pauperisation unless we can change the US Patriot Act.
Well, there's no need, I mean, obviously Congress is now in the middle of having new legislation, deeply imperfect, and that's what's currently happening. Although it's, you know, we're monitoring that, and it really is it's going through all the wrong procedures. Jim Sensenbrenner, the Republican congressman's legislation is going to be much better, but the stuff that's happening in Congress at the moment would create a better environment, but it really is imperfect pre-legislation. But under the Patriot Act, you're right, the environment is not the correct environment, so you're making a good wider point about what the current environment is for anything to happen.
Well, I'm not sure whether it would provide a watertight defence against US jurisdictional claims or even successful jurisdictional claims. I mean, I think it's partly a matter of location of infrastructure, it's partly a matter of location of the users, of the citizens, and that's precisely what we're trying to sort out in the new data protection regulation. So, you said that you've already name-checked the court judgment this week, so I don't think by having all the infrastructure located in the EU, you're necessarily going to solve the problem. I don't think it's as simple as that.
Yeah, I think there already is quite a lot of uncertainty, and maybe there is, you know, a degree of organisation already. I mean, there are, as the gentleman earlier said, you know, there are these different legal statuses already, depending on the structures of the servers and where they are and who they are and all this kind of thing. So we need greater legal certainty, and at the end of the day, we need the protection of the EU citizens' data being at the core of it. That is more fundamental than the location. But I think that if we move further down that road, if we move further down a rights-based model, then we can get a greater degree of certainty all around. And it may be, you know, I'm not an expert in these things, it may be that the EU cloud is a component of that certainty, but it's the rights-based approach that is the thing that we need, and we need that for the protection of the EU citizens' data.
Paul, any more to add?
Well, I'm not familiar with the threats that you're talking about, but I am an opponent of the US Patriot Act, and if it was to extend its tentacles over EU citizens in the broadest sense, I'd be against that.
Okay, thanks.
Yes, I've got a question to Sarah. You mentioned that you are reluctant to debate the legal nature of the application for Edward Snowden. But you were involved enough to comment to Guardian that Snowden appearance in news and be described as high-profile stunt. So could you describe your view at that point? Because we've checked the quote and appears to be correct.
I don't off the top of my head remember that comment. I was not entirely sure what it was going to achieve, and I think the problem was the lack of interaction. But I certainly didn't oppose the video appearance. Indeed, someone tweeted today, and I replied, see my press release on my website, where I knocked the Tories for opposing the video appearance before the Civil Liberties Committee, the Libe Committee. I wanted to make sure that there was some probing questions as well, but I certainly didn't oppose it, and I just wanted to make sure that it was a real interaction rather than just a one-sided platform.
Okay, thanks. We can always come back if we've got time afterwards, but since there are so many other areas, I'd like to explore some of the others. I'd like to pick up on something that Paul said. I'm really glad you mentioned this business about going down the pub and starting to tweet, because this brings in the whole issue of freedom of expression and the limits of freedom of expression online, to the extent that online is different, or is it the same? So when, for example, you're tweeting, is that the same as talking with some mates down the pub, or is it a public broadcast? I mean, I'd like each of the panellists to comment on where they think the line should be drawn, and for example, in reference to particular events recently, when you call the police, because it seems to me that we need to establish what the kind of social norms are for online activity and when it becomes a kind of criminal matter. So, who'd like to start on that? Well, Paul, since you raised it, perhaps you could comment on that.
By all means, Twitter is not a conversation of the kind that you would have with your mates in the pub. You are publishing something. From a defamation point of view, it is libel rather than slander. Now, if you do produce something silly, then you can try and delete it, but of course the chances are it's going to have been retweeted several times, and there's not a lot that you can do about it. So I think really what we have to do is be courteous to people on the internet. Certainly, I'm a kipper. I've got my Twitter account myself. Sometimes I'll post something and I'll get the most foul abuse from people. The simplest and easiest thing to do is simply ignore them and block them. But I would like to see more courtesy online, because exactly what I was saying at the beginning, there is nothing which is ever going to be deleted permanently on the internet, and you must always have that in the back of your head before you put your fingers to the keyboard.
Yeah, I mean, a line has to be drawn. It's difficult. It's always difficult. I mean, I guess the key thing for me would be when you're in that territory of things which are which are criminal acts already. I mean, if you're talking about hate speech that is liable to trigger racial abuse or attacks in any way, if there's incitement going on in any language, whether we're talking about Twitter or whether we're talking about the internet, or generally, so if there's a connection to something that is potentially criminal and leading to criminal action, then obviously that's in one category and that has to be dealt with in a certain way. If you're talking just about sounding off and being nasty to people, there are norms and we should respect one another. Absolutely, we should. But in terms of what's permissible, I think as long as we're not going down that route of incitement, of hate speech, or those other illegal things, then there needs to be quite a high degree of tolerance materials out there. But I would just add one to that, which I think is good, that list, and that is stalking. I think certainly with some of the language on Twitter, it does appear, at least to me, that some of that has a kind of, it's like cyber stalking really. So I'm very, very uneasy about, just allowing for free for all on that side.
Yeah, I mean, Lib Dems, under the last Labour government, there was an attempt to criminalise insults and causing offence, and Lib Dems robustly stood up to that and insisted that criminal law should only apply to incitement to hatred. And I think that would, they would also cover harassment as well. but there is no right not to be offended, there is no right not to be insulted. I'm very sorry that I believe it was a UKIP councillor who contacted the police in Cambridgeshire, who went round and called on somebody. I think my colleague Julian Huppert, who's MP for Cambridge, probably had some role in making sure. There was an apology, I think, from the Chief Constable. I mean, that was absolutely outrageous. I mean, I rely on the report in The Guardian, but it sort of said that the police said, oh, no, you haven't committed a criminal offence, but we'd like you to take them down, the tweets down. I mean, that's a ridiculous situation. You're either within the law or you're not. You can't go around and lean on people. And for the police time to be spent on such a thing was deeply worrying. Goodness knows, despite the Chief Constable's apology, the fact that someone somewhere in that Cambridgeshire police initiated this knock on the door for this guy was outrageous, and I'm sorry that it was initiated by UKIP.
I mean, I think the visit from the police is deeply worrying, and I think it illustrates the following, which is the law is quite mature. We have libel law, defamation. I mean, the law is mature. I'm a law graduate too, and basically we're told very early on that, as long as up to the point of harm, we're in a free society, we want to have as much freedom of expression as is possible, up to the point where you start harming people, so you don't go into a crowded cinema and shout fire. I mean, that's the point. And the problem at the moment is we're simply adjusting to a new environment. We're adjusting to the proliferation of Twitter, the internet, and the use of all of this. And we're getting these disturbing manifestations of enforcement perhaps doing the wrong thing. This example was clearly enforcement doing the wrong thing. The police actually turning up to somebody's door. It should be a very frightening thing to happen. I understand an apology has been given now. I mean, this just can't happen. I mean, this is awful in a free society. I read the particular tweet in question. We all suffer abuse as politicians on Twitter. It's really horrible. I don't like it. As you can see from my demeanour, quite a sensitive type person. I am like this all the time. So I hate it. I became a politician before Twitter, the internet. I could deal with letters. I became a politician before email and mobile phones, in fact. Started very early. This new environment I actually don't like. I hate it. Hate every minute of it. It's abusive, it's horrible, but it's a new paradigm. But the old law applies to it. So we need to readjust in terms of how it's enforced. But much of it is quite mature. So I just think we need to be sensible and work out what the rules are. But the rules are in fact quite mature, and I think the first contribution was correct, that it's about the basic laws of libel, defamation, and people need to get used to that and watch what they're doing, watch what they're saying, because that's the law. And we need to watch what we're saying about people, but we're in a free society, we need to get the balance right. One of the things I keep hearing is, not to talk about the balance between freedom and security. Don't talk about the balance between freedom and harming people. Well, we have to, because that's what we've always done in lawmaking and jurisprudence, and that's what we're going to have to do with the internet too.
Thank you very much. Before we throw open the floor again for questions on this particular topic, I'd like to broaden it slightly by asking one more question of the panel, which is to do with web blogging. Because although this has a lot to do with copyright, which we'll come on to afterwards, it also has to do with freedom of speech. Because one of the fears is that when you start to use web blocking too freely and too indiscriminately, you will actually lead to a loss of freedom of speech. For example, some of you may know that in Italy, there is now something called the authority, which can actually shut down websites almost trivially. So it's getting very easy to shut down websites without any thought about the collateral damage. And so I'd like to ask the panel to comment on their thoughts about, again, where we draw the line. When we shut down websites, what safeguards we might need or what due process we should have.
Me?
Yeah.
Yeah, I do actually find this quite confusing. I mean, I'm instinctively against blocking of websites, and certainly in European Parliament when we've had we had a lot of debate over online child sex abuse and tackling that, and also in the previous telecoms package, which was in 2009, which was in the context of copyright infringement. And I think there was a big battle over an attempt in the European Parliament to kind of enshrine at European level a three strikes and you're out law, like French Jalopy legislation, and we managed to win quite a lot on that. We didn't manage to enshrine in EU law. There had to be a prior court decision because the member states, 28 member states, or however many there were there, would not accept it. But we got a lot, I think, into that law, which was about some prior process, due process, fundamental rights protections and so on. So you couldn't just charge around cutting off people from the internet or blocking access. I mean, I think my preference is to have a takedown process. I think we have something called the Internet Watch Foundation in this country, which I think is not in statute. It's a kind of informal arrangement between the police and the ISPs. As far as I know, it has broad support, though I'm not the world's expert on it. So my preference is to have a sort of high threshold for takedown of those sites which are truly horrible and that everybody could agree are truly degrading, rather than a blocking of someone's access to a website. So you know, it would be a last resort to remove a website which was grossly disgusting, rather than trying to penalise individuals by blocking their access. And certainly, I mean, there's been some, I haven't had time really to look at it, but I'm glad to see that the Digital Economy Act has ended up with a bit of a mouse, I think, in terms of some voluntary agreement between the ISPs and the music industry. I always thought that needed to be dealt with, and I believe that it, to a considerable extent, has been by alternative methods of music download, because there was a severe threat, I think, to internet freedoms from a lot of the talk of 4 or 5 years ago. But I think we've managed to head off a lot of that, but I'm sure it will keep coming back in one form or another. And of course, if you go down the road of blocking, you are just giving comfort to authoritarian regimes, which would like nothing better than to cite the West in terms of a role model.
Paul, perhaps, what's UKIP's position on blocking websites?
Well, I'm not going to tell you what UKIP's position is, but I'll tell you what my position is. All websites that promote or encourage criminality can and should be pursued under the existing criminal law. But I don't want our country ending up like China or Turkey, where functionaries of the state err on the side of caution, if I can put it that way, in the most kindly fashion, and shut down things which are not actually offensive, but merely pose a threat to the established organs of the state. Any provisions of this kind are likely to be used to cover people which are not actually committing criminality, but are threatening the governments of their countries. So I'd be opposed to that. And the other thing that I'm opposed to is, as I understand it, even though I already said I refuse to have a smartphone, there are provisions with the latest Apple products, for example, for the functionality to be shut down in crisis situations. So, whereas in the olden days you could take some film of police brutality, etc., if it was happening in front of you, that can now be shut down in that sort of a scenario, and I'd be utterly opposed to that.
Yeah, good.
Yeah, I mean, I currently feature on many hate websites, and many racist websites named, and I have done since the internet began, and I would fight for them to stay open. So it's really it creates a chilling effect to begin to close them down until EU feature criminality, but we have to define what criminality is and what the dark web is exactly. But up to the point of even being named, and as I say, I'm named on some of these websites, and it's a horrible thing, but I just choose not to look at them. There may be an issue where they actually put your name and address, but those are the points at which the law should say what it has to say, and that's my point earlier. But I think the law is mature in these areas, and we shouldn't discount that. It's more mature than we think it is.
Thank you.
Yeah. I think the starting point should be that we want and we should aspire for a free and an open internet and a free and an open exchange of expressions, views, opinions, and that we should basically have a framework which allows for the maximum of that. Having said that, that can't be a total free-for-all, and this, in a way, is the point. And I am in on this, concurring with, I think, a lot of the other comments on the panel. I mean, at the end of the day, where you're talking about criminal activity, when you're talking about degrading material, that does need to be dealt with and handled, but it is a criminal matter, and I think that's the point at which the technology has to be looked at, and where we're talking about taking down those sites, if that's possible, if that's technically possible. If they're located somewhere else, then obviously you have to look at other mechanisms, but it needs to be within a legal framework, and I'm very uneasy about informal arrangements and ISPs erring on the side of caution and acting within their own, guidelines. I mean, that's a model for policing the internet informally, and that isn't the way we should go with this. So we need to be very, very careful, have a minimalist approach, but obviously when we're talking about the kind of things that we're all in agreement of, that they will need to be taken down and blocked if that was the only route.
Thank you. So I'd like to ask questions from the floor on this topic, general issues that have gone already around there.
Where's the other microphone?
So issues of censorship. Sorry? Yeah, let's do this again. So I can try and do this again.
Thank you very much indeed. My name is Syed Kamall, and I wear 4 gagging orders with pride, which means 4 councils of the UK have asked WordPress at the time to block my site for a certain while at the time. My site is called Victims Unite, and I was really amazed that you said what we really need to do is define criminality, because I'm talking about white-collar crimes committed by officials in the UK. And the most heinous of the crimes that I've discovered is what generally goes under forced adoption. I find it really, really difficult to talk about the subject because it's not known, because of the secrecy of the family courts, which are abused to legitimize the stealing of children. On the 19th of March, I made a presentation to the Petitions Committee in Brussels, and the committee promised that a fact-finding mission would take place. I very seriously would like to ask your advice for what we, the people who are concerned, the parents whose children have been taken, who were in Brussels with me, and everybody else on Facebook and wherever who is begging to find an answer as to when and how they can prevent their children being taken or can get their children back. Because it is an elephant in the whole country, not in this room. It is so terrible that if you Google forced adoption, you will find a lot of answers. I would really ask for your advice, please.
So I wasn't terribly clear in what country are the forced adoptions?
In the UK, and it's one of
Ukraine.
UK, this country, in the UK, this is one of the horrible things. Hardly anybody knows about it because of the secrecy of the family courts. So when you ask what is criminality, I mean, I like to consider it to be criminal when 2 of the Portuguese children are supposed to be adopted against the will of the parents. The family has lived in in this country for 11 years, and 5 of their children were taken. The police come in the evening and take all of the 5 children. They were arrested 2 days after we came back from Brussels, and I listened to the transcript today, and I'm going to try and help them. It is really terrible.
You said that some sites were blocked. Can you say a little bit about which sites were blocked and how?
The Site Victims Unite, my blog, which was blocked by Swansea Council, by Doncaster Council, by Haringey Council, and I forgot the 4th one now. Lincolnshire, of course.
How do you mean block? Because councils can't block, so...
They contacted WordPress, and WordPress thought these were legitimate documents that they had seen.
Well,
and before I then opened my next blog called Punishment Without Crime, I asked them, are you going to block this again? Because what we are up against is this pseudo-legality of the family courts.
Well, I know this, I mean, this sort of goes into areas out with my knowledge. I mean, I know there's a lot of controversy around the family courts. I think there have been moves actually to open them up a little bit recently, because there has been, I think, legitimate criticism of how secretive they are, and I'm pleased. I mean, there are Lib Dem ministers in the Ministry of Justice, so I think they've probably contributed to that, trying to open up. In the specifics, I mean, I'm sure there are sometimes reasons, social services reasons, why children are removed from parents, because as we know, there's a lot of criticism that sometimes the decisions are wrong. I mean, I would be completely unable to comment on any cases that you've taken up, because I don't know the details. But certainly, I mean, unless it was specifically a child protection reason why Haringey Council, Swansea Council has persuaded WordPress to block your site, I mean, I simply don't know. There could be, but maybe there aren't. It sounds to me that there does need to be a legal resolution of what you're the situation you're describing.
I mean, I think the issue is that it's rather outside the purview of this meeting, which is unfortunate. But so I think, you know, I think we have to move on to a different question, because there's nothing the panel can say useful that will help you, I'm afraid. So I think I have to leave it there. So are there any other questions on the issue? Could you pass that?
My question might actually help this lady relate to the subject. My question is relating to, we're discussing whether or not it's necessary to create a legal framework to address the 21st century, the internet, but I would propose that perhaps it would be wiser to adapt existing legal frameworks, be they commercial law, criminal law, whether for child pornography, copyright, whatever it is that we're trying to do, rather than blocking the internet, simply improving the existing legal framework so that the courts can address these issues between the parties involved, rather than creating this sort of new legal existence, this new area of law outside civil, commercial, or criminal. I mean, I have a background in law, so in my experience analyzing copyright, I found that a lot of the time issues could be better addressed by adapting existing legal frameworks to the new age rather than trying to curb progress. Mm-hmm. So I was wondering what the panel thought on this perspective.
Mr. Chairman, I've got to make a phone call. Just be gone for a couple of minutes. My apologies.
All right. Probably stop the police. But I think what you just said, sorry, I realise this has been filmed and, ironic doesn't travel down there, whatever it is you're filming. You see, that's the problem with technology, isn't it? It's kind of, yeah. And I was talking about hate mail earlier, actually.
Stop digging, Claude. Stop
I was talking about hate mail earlier. I used to be director of a refugee immigration organisation, and when I was first elected to the European Parliament, I was getting so much hate mail that a panic alarm was installed. But I was able to open the hate mail and get the calls. Now, if you're subject to something, it's more instant. But you said something about adapting existing law, is that right? Adapting existing law?
Well, the general criminal law to the new...
I mean, that's what I'm in favour of, because I think the law is actually quite mature in these areas, but I think enforcement and communication is very poor, which ended up with this instance of a complaint being made to the police, on a reasonably benign tweet. I think. I mean, that's just my objective opinion. Other people have different opinions. And, you know, has somebody been visited by 2 police officers, which in a free society, you know, that's a big thing to happen in somebody's life. I mean, it's something you'll remember for a long time. And then that's been publicised all over the place. Now, the point is that the law exists already in terms of print, copyright, publishing. I mean, it's about extending those principles in an intelligent, modern way to the present environment. Thinking about enforcement as well. I mean, we're putting a lot on the police at the moment too, in this situation. I mean, I just want to make that point because it really worries me that we're in that environment and how we're resourcing that environment, particularly in relation to the internet as well. I mean, we looked into this, by the way, in our inquiry. I mean, we spoke to all sides in this, by the way. You know, hackers, enforcement, intelligence services. I mean, we have to look at the existing law first before we suddenly come up with new laws. I just want to make that point.
Okay.
If I may just add to my question, perhaps the issue is more specific to procedural law rather than substantive law, because the substantive law is actually quite comprehensive as is.
Yeah, that's how I agree with you.
I mean, I would instinctively agree with you. I think that's right. That we just need to adapt existing law to a new framework. Secondly, I would prefer, and I think this is my party's position, to go first look at the civil law and not jump to the criminal law, because I mean, copyright infringement, for instance, is a civil matter.
But that was my point, was to keep things in their boxes rather than create an internet law that would be either criminal or something else.
I agree with that. So that was my first point. I agree with you. You shouldn't create internet-specific laws, except for things like net neutrality, where you know it has to be net-specific. Second point, prefer civil and criminal only very much as last resort for things which truly are incite to hate or whatever. But thirdly, we need legal clarity. We can't have a situation where police officers turn up at someone's door and suggest that they take down a tweet. That's not acceptable. We need to have, we need training of police and law enforcement, which clearly they're out of their depth, I think, at the moment.
Yeah, speaking as the non-lawyer on the panel, I mean, I have some sympathy with what you're saying, and I think, yes, there's no point inventing something if it's not needed. So I think we should push the existing frameworks as best we can, and obviously make use of those if they can be extended. I think one of the difficulties is, you know, you might, and I don't know whether you would, but you might end up with a very, very complex series of responses, whereas actually a paradigm jump, a paradigm shift could actually simplify. I suppose that's the broader kind of point, I suppose, and that sometimes that is necessary. I studied philosophy of science some years ago, and in that context, when you actually look at the way science has progressed, there are these paradigm shifts at various points, and sometimes it's necessary. Now, I'm not saying we're at that point now, but we could be. So I think we need to be open, keep the dialogue going, and use the existing frameworks where we can.
Any more questions on freedom of speech? Somebody hasn't spoken before. Back there, please. Could you pass the microphone in the corner at the back?
Monica Horton, visiting fellow at London School of Economics. I have actually 2 questions for you, following on from the previous discussion. The first question is, what is your opinion about getting or mandating that there would be a court order before either content could be taken down or websites could be blocked? So in other words, enforcing a court order, so anyone who wants to get a website taken down has to go to court first, so at least you get a court ruling. And I want to note in that context, Baroness Ludford, you have rightly mentioned the 2009 telecoms package and the battle there over the issue of court order, which was in the context of strikes regime. My second question follows on from the previous questioner. I think it's not that the current law, whether the current law is comprehensive and can do the job. Sure it is. But surely the problem is that the corporate interests here want to get current law changed to suit their own purposes. One purpose of which might be that they want to impose some sort of blocking regime. And I wonder how, particularly the two panellists who are already in the European Parliament, how you deal with corporate lobbying in this context.
Okay, so we've got court orders and lobbying of this particular issue. We'll talk about lobbying later on, but we'll talk about somebody wants to start on that.
Who wants to start? Just because I'm in the middle doesn't mean I should start.
So I know this is a difficult issue on the lobby. Can I just take one part of it? Because in terms of taking down websites and court orders, I'm going to get myself into difficulty because I'm not an expert on it. So I'll just, on the issue of lobbying, there were over 4,000 amendments in the Data Retention Regulation, and I had more to do with the directive because it was one of the Socialist and Democrat rapporteurs on that. But on the regulation, of course, there was huge corporate lobbying, and I think in this sense, I think you're on the right track. That corporate power can, that their interests can indicate, whether they, because they're the point is there are huge business interests here in relation to selling on the internet. The commercial imperative was huge, and I think it's a testament to the fact that Jan Albrecht and various shadows and other colleagues, and I also pay tribute to Sarah's work in this area, because a lot of people worked hard collectively to get this piece of legislation through. I was very dubious as to whether we could do it in the end, because there was huge corporate lobbying, and I thought, is it possible to regulate here with the amount of corporate lobbying there was? Because they would always look at the way that they could get the easiest way to maintain their business interests, keep their commercial websites going, sell the easiest way, and it was a very worrying process in some ways. But I think the amendment process, in my view, was the way in which we worked that out. But it was a huge amount of work by MEPs, and I think not publicised, of course, particularly here in the UK, for various obvious reasons, and just not much reporting about those sorts of things. But I think overall we got that right. I think you're right to highlight the corporate lobbying in relation to websites and the commercial side. My plea would be, even if you're more anti-EU, while we're there legislating, that was the biggest piece of legislation in the EU's history, that the media and other interests, even if they're opposed to it, have to communicate it. And it wasn't communicated to the regulation.
You're obviously an expert on the 2009 telecoms package, and you will know all the ins and outs of Amendment 138. And we did indeed, I think ALDE Group was very much in the leadership of that, trying to get the requirement for prior ruling of an independent authority. And I'm reminded by my note that unfortunately the Parliament Legal Service said that a requirement for prior ruling of the judicial authorities went beyond the legal base, which was Article 95 of the treaty. So we're very, very unlucky here. So that rather undermined the Parliament's case, and we couldn't agree with the Council. However, in what became Article 1(3)(a) of the Framework Directive, we got quite a lot, I think. We got about effective judicial protection and due process. I think we got the word prior in there somewhere. But yes, I mean, in short, to be short, my definite preference, and that of our group in the European Parliament, is to have a judicial decision. Then I sort of come up against this Internet Watch Foundation rather voluntary thing, which, as far as I can see, is not controversial in the UK. So I suppose if it ain't broke, don't fix it. So that's because that's in a very specific area. but in other areas I would very much want, I suppose you could stretch that to a DPA, the Data Protection Authority, if not a court, but certainly not at the behest of corporate interest. Just going on quickly to the Data Protection Regulation, I mean, sure, there was a lot of corporate lobbying. There was also a lot of NGO lobbying, let's be clear. Perhaps I can just put in a personal note here. Somewhat to my bemusement, since none of the 120 amendments that I tabled come from industry at all, I managed to end up number 6 or number 7 on a website called lobbyplag.eu, which I believe was a sort of plagiarism or something. I was a bit mystified by this. Anyway, and I, in fact, I ended up asking Joe McNamee of Edry in about October last year, why am I on that? Because if it's meant to be about picking up corporate lobbyists' material, I didn't. None of my amendments can be traced to corporate lobbying. Why am I the 6th or 7th on the Lobby Flag website? And he said, oh, that's just because you're horrible on data protection. Personally, I don't agree with that. I don't think I'm the 6th or 7th worst MEP in the European Parliament on data protection, but hey, it's a free world. But I just wanted to put that on the record, that none of my amendments came from any corporate interest whatsoever. And you just got to, I mean, some of them have some good ideas, some NGOs have good ideas, and you just got to assert your independent parliamentary judgment on where the balance lies and what fits with your own political and personal outlook.
Yeah, just on the data protection regulation and the amendments and the changes, I don't know how familiar people here are with the proposals, but the proposal, there's one element which is the fines on corporations for non-compliance with the what would be the rules in the data protection regulation to protect personal data. And the proposals for the Commission were, this is for maximum levels of fines, €1 million or 2% of a global annual turnover of the company, whichever is greater of those two. Now, European Parliament position amended that and took a different position. Their position was much more robust in relation to the corporations. So rather than €1 million fine, the Parliament is proposing a €100 million fine, or rather than 2% of global turnover, the Parliament is proposing 5% of annual turnover. So it's €100 million or 5% of annual turnover, whichever is greatest. That's the Parliament proposal. What will happen now, as I understand it, is this will go back to the Council of Ministers. It will come back to the Parliament with the new MEPs in the next Parliament. It will go to the Council of Ministers and we will see what will happen to these proposals. And the issue of corporate lobbying is an important issue, and certainly it's an issue at European Parliament level, which is why Green MEPs and I'm sure others have called for more stringent rules on transparency and registering lobbying interests so that we know exactly what these lobbyists are doing. But the problem is not simply happening at the European, the EU level. The problem is happening at member state level. The problem is happening in Westminster, and these are problems that are happening with all the parliaments, with all the jurisdictions. So I would encourage and urge people to pay due diligence and attention to what's going on in Westminster. And it will be very interesting to see if the lobbying that has taken place will happen again in relation to the national governments, and whether the national governments try and get the figures back to those lower levels that were proposed by the Commission.
Okay, Paul, there's an important issue that Alan talked about, perhaps you'd like to address, which is business of lobbying both in Brussels and also with national governments. I mean, does you see that as a big problem? Do you want to address it? I mean, where do you stand on lobbyists?
Not very keen on lobbyists at all, as it happens. And unfortunately, in many instances, the lobbyists are actually bypassing our national parliament and going directly to Brussels. Indeed, in my profession, the bar, there is a bar council office in Brussels. It is indicative of the fact that far too much of our law, more than half, a minimum of 53%, up to 75%, is actually made in Brussels. And that merely underlines the fact that we have to get out of the European Union, and we can control our lobbyists by simply having them hovering around Westminster like the flies that they actually are.
Okay.
Could I forgot to mention something. Sure. Can I just say that my group fully supports making the transparency register compulsory. and extended to all the institutions, not just the Parliament. And also recently in a report where we made a strong contribution was to call for votes at committee level to be recorded votes, what we call roll call votes, as well as plenary ones. So there is a lot still to do, and access to documents, quite obviously, is a pretty sorry story at the moment, and it is not absolutely not good enough, the ability to scrutinise public documents, and the Council member states come up with all kinds of reasons why documents can't be made public, and there's a long way still to go, I'm afraid, in the next Parliament.
Did you?
I just want to say something really important about lobbying. And that I tabled successful amendments on blacklisting of trade union members, and that they should be able to, that should be exposed, that they were successful amendments. The trade unions I work with in the data protection regulation for which that was successful could be seen as lobbyists, i.e. they were lobbying me, I was talking to them, and it's a horrible word, lobbying, because it has all sorts of connotations, but open rights group, NGOs, small organisations, independent NGOs are all lobbying. NGOs are the biggest lobbyists in Brussels and highly effective. So let's just be careful as to how we talk about so-called lobbying, because it includes the organisation bringing us here tonight. And that organisation has taught me a huge amount during my recent inquiry, the inquiry that we've just done on the allegations of Edward Snowden. So let's just be careful. It's a horrible word, but unless people get together and tell politicians what they want, that's a critical part of democracy. So let's just be careful. I don't want that to go unanswered.
Thanks. Have you got the...
I hope you don't mind, Paul, but I've got a specific question for you on the protection regulation. You suddenly thought, obviously, that as you should leave the EU and not make regulations on these kind of issues. But don't you think that data protection specifically, as something that affects companies outside the EU who then operate in the UK? Do you know what I mean? Like, as in, EU companies that might be based anywhere else have UK customers. And there's that relationship, there are UK-based customers that people in Poland might be using. And therefore, there's not really that border division that really matters so much when it comes to the internet. It doesn't make any difference where you are if you're using a company online. Do you think, therefore, it's important that we all have the same kind of protection and when it comes to data protection across Europe?
I must admit I'm not familiar with the latest provisions that are emanating from the EU. I'm not surprised that they are expanding their operations even further. The only observation that I would make is that we had, firstly, a Data Protection Act in this country in 1984. It was updated in 1998. It will still need to be updated as technology advances, but the British Parliament is more than capable of making those decisions itself. I don't want to see any further extension of EU law. So even if it sounds like a wonderful thing in principle, and I do admit that I'm not familiar with the proposals as they stand, I would be against it in principle.
Is there someone else who hasn't asked a question? Lady in front there.
Thank you.
I've just noticed a little contradiction in some of your piece. You've all sort of come out support of this ruling that says Google can get rid of irrelevant information about people, but you are broadly against blocking websites so illegal. I mean, what do you really think about that? What about the impact on freedom of speech? Of Google being able to take down things that people consider irrelevant? For example, the Conservatives tried to delete a lot of their old manifesto because they changed it. Now they can do that because they can claim it's irrelevant.
Perhaps, yeah, I mean, there's a question that was asked before about this right to be filtered. We'll talk about that now.
Yeah.
I'll just answer that briefly. It seems a very odd ruling indeed, because ultimately Google is not hosting these websites, it's just sending a pointer to the website, so I'm not sure it's actually going to have any practical application much as I loathe and detest Google, I much prefer using DuckDuckGo. But it's really a bit of EU willy waving, and it's probably going to have no practical effect.
Yeah, I think on this question, I think you have to look as well at the privacy issues and at the personal issue, and I think imagine if it was you being on the receiving end. Firstly, to say though, if it's someone in the public domain in political life, and the example that Conservatives, I think it is different, because if you're in political life, it is different to something that happens privately. Obviously, if you're in public life and it's a private matter, then that is an added complexity. But so I would take a very different line over Conservatives taking down their policy material to a case like this, which, as I understand it, was about an individual to do with a house repossession because of a personal debt that was no longer relevant to anything, but his name kept coming up on the list. That's my understanding. So I think you do have to look at it in terms of if you were the person who was having a very a historic piece of information about you, which was no longer really relevant to anything, popping up all the time on a search engine about you. The matter had been dealt with, but nevertheless it kept, in a sense, coming back to haunt you. And I think in a very small range of cases, there is an argument to say that from the person's perspective, they need some kind of redress. Whether or not it's the right mechanism, that could be another discussion, but that sense of personal redress, because if it happened to me, I certainly wouldn't be very pleased about a piece of old information that was totally irrelevant, although I suppose I am kind of in public life, so maybe one of you or whatever. But you get the point. If it's a private piece of information, it is relevant to, I think, I suppose what I'm saying is the right to be forgotten under certain circumstances is
Doesn't it set a legal precedent? This is the thing.
Well, yeah, I mean, I think the devil is going to be in the detail, which is precisely why we need a data protection regulation, and I hope this, and there's been some comment by some people in recent days, it does indeed, I think, give an incentive to the Googles of this world to actually want a data protection regulation, which they have not been keen on, and this would update the existing 1995 Data Retention Directive, which, by the way, is what the UK Data Protection Act 1998 enshrined, so it's not a UK Act, it is implementing an EU directive already. Whereas perhaps some of the big tech companies have hoped that data protection regulation will fail, now they might hope that it would succeed, because we need more clarity, more detail than the court judgment this week has given. And indeed, I mean, my group always took the view that the headline phrase, right to be forgotten, was both misleading and undeliverable. And we managed, and we got agreement across the political groups. It's not in the text that the Parliament voted in March. The heading of Article 17 against right to be an anorak is just right to erasure. That's the first point. And then secondly, both that text and then it cross-refers to Article 80 on freedom of expression, says that any right to erasure is subject to the interests of freedom of expression. Now, the court already made, perhaps not sufficiently strong in my opinion, references to the public interest, and particularly if someone is a person is a public figure. But that all has to be teased out, both in the text of the data protection regulation and indeed in the more detailed law that guidance that the data protection authorities would make under the data protection regulation. And I think that we parliamentarians have actually been very conscious of the freedom of expression interest here. Now, how it will end up as a matter of litigation and judicial determination, but I don't anticipate a flood, frankly. And I think the hysteria that's been seen in some quarters in the last few days is unwarranted. I don't think it's going to lead to masses of people wanting all their data deleted, but I think it does empower people in specific circumstances to try and get data erased. And what the court has done is assert the individual ownership of that data. Secondly, it completely rebutted the Google claim not to be subject to European data protection laws because they claim that the search engine is incorporated outside the EU and that its subsidiary in Spain was only selling advertising space. I mean, that argument is used in tax affairs as well. And the court said you're a processor and you're a controller of the data. Whereas Google said, oh no, it's nothing to do with us, Gov, what data passes across our servers. I think that's an important principle the court has established. But we must make sure that, of course, we do not imperil freedom of expression either for journalists and other news media or for historians and researchers and so on. And in fact, the Parliament made that clear in the text, clearer than the Commission had done, that it's also about historians and statisticians and researchers.
Yeah, no, I would never support a right to be forgotten. And Sarah's right to say this. The reason we're supporting it is because there has to be such a thing as privacy. And what is privacy? Privacy law, therefore, has to be some sense of balance. And in law, there's always some point at which you assert some rights for an individual. That would not include, at any given point, the Conservative Party wiping out its manifesto, because that is like being in China or something. And that would include my party and any other party doing it. So that would then be the data regulation authorities, precedent in courts, and all the rest of it. This is a good judgment because it asserts what Google's responsible for, and it asserts a privacy right. And I think that's correct because there will come a point as we move in this brave new world where you'll have to assert some privacy rights. Now, of course, journalists and others are getting concerned because, as Sarah quite rightly thinks, we think there's going to be a flood, but I just don't think that's the case. I think we're asserting privacy rights. Now, people may disagree with that, but I would say look at the judgment. And yes, it is a misleading term, the right to be forgotten. But in a sense, when you've got a situation, and I address this to people who dislike the EU and all the rest of it, one of the downsides of Euroscepticism is that you just don't get much reporting of all of this stuff. And this right to be forgotten term has been used. I see it in used in quality newspapers, very often so-called quality newspapers. It's just a term so that people can, pick it up, But it's a right to erasure, and it's a limited right, and it always has to be, and there will be safeguards in it. But look at it in that way. But of course, we're now going to get this deluge about, history being wiped out, and certainly that's going to happen.
Okay, thanks. So we broadened it a bit to include this right to erasure. I'm keen, if there's anyone who hasn't asked a question before I go back to people, I will go back to them, but is there somebody who hasn't asked a question who wants to ask about this or about the freedom of speech or data protection, something, any of those areas? If not, I'll... Okay. Do we have a question? Yeah. Anyone not had a question who's dying to ask one now? Okay, I think somebody there was asking first and then I'll...
Well, I think I looked at the Google judgment in quite a lot of detail, and I do think it is very balanced. And I think it goes to, I think it's very, very telling in fact that there was something today suggesting that news came out of Google Germany is promising within the next couple of weeks they will have a mechanism for people to start making these requests on a larger scale. I'm very much in favour of the regulation, and I think the Parliament's got the right balance. I guess one of the issues for me as well is that of course it still has boundaries where the web doesn't. And Tim Berners-Lee has been calling for this idea of a Magna Carta for the web, which I take to be a kind of a set of getting an agreement for a set of kind of global principles. I'd like to kind of ask the panel's views on how we can expand out beyond to get a kind of a real set of global level playing field that will give both wide protections to to everybody, regardless of where business is and where data is held.
Okay, great question. Danny, do you want to start first? I start with you before.
I think that's right. I mean, I think the idea from Tim Berners-Lee is a good one and one that does need to be worked on and developed. And I think, certainly what the Greens are calling for as a manifesto commitment is to push for, campaign for and work for a bill of digital rights. That would be through this European manifesto, so that would be through the European institutions. But it just doesn't preclude of being operative at other levels. And we would argue if something good gets developed at the EU level, then something very much like it could be a universal thing, and that could get broadened. Or if the development takes place at other levels, then that would potentially supersede something that began at EU level. I mean, obviously at EU level you've got the legal framework as well to work with, so I think the thinking is very much that the MEPs can take some of this forward and can start to make legal protections within that context. But certainly defining these as positive rights and a positive set of values that we can then build upon, I think is the way to go with this. Certainly net neutrality, which I guess we might talk about in more detail, I don't know, but how that is defined, what that means, and how corporates and other interests. But net neutrality is an element within that, and we would like to see certain fundamental elements within a kind of a Bill of Rights. And let's move the debate on. So what's in the Bill of Rights and what does it look like and all of that?
Yes, I mean, I would ideally like to see an international agreement, just as that's our ideal for data protection. But I think you have to start by making European rules, and I'm very much in favour of the Bill of Rights, Magna Carta, or habeas corpus, whichever resonant phrase we're using at European level. Then realistically the next stage is transatlantic, and then international. Now I'm sure this brings in issues about internet governance, on which I'm absolutely not an expert, and there's been this recent Net meeting. I want an open, plural internet and certain sort of guaranteed rights. And I'm glad we're going to talk about net neutrality because we've been working on that recently. So I think our ambition should be an international agreement, but I think we have to start at home, UK and Europe, first of all.
Just beyond internet neutrality.
No, can you just come up with it? You don't really want to say this. Okay. Can I just ask whether, if you don't like EU things, what about universal global things? Where do they stand?
Well, I'm not a great fan of the United Nations either, to be honest. But I can't possibly see how that is going to work. You have different judicial systems right the way around the world, not only as regards privacy law, but credit history, openness questions, public records, even records of births, marriages and deaths, things as mundane as that. I wasn't aware that an international Bill of Rights of this kind was being proposed, but I'll simply say good luck with that. I don't think it's going to come to anything.
Okay. I'll just explain what we're going to propose.
Okay, Claude, just
sorry. No, it was my fault. In our inquiry we said this pompous term, digital habeas corpus, which was making it sound British. And then I was told to not do that because it was a bit Winston Churchill. And then it was Digital Bill of Rights, which is a bit more American. And then they didn't like it because it was a bit too American. So I don't know what it is at the moment.
I don't know, it's your report.
It's my report, but anyway, so it was my fault, but it's not really going to be international.
Great job.
The point about it is it just has a whole number of action points which will go into the next Parliament, which is important because normally reports like this just dry up at the end of a mandate. So that's don't worry. There's no just say to our UKIP colleagues, no international law has been proposed to which you will faint. Don't worry about it. It's a digital bill of rights which just encompasses all the issues we've been talking about tonight, so that you can keep an eye on what we're doing legislatively and where we don't have a competence, what we're saying at least, and what member states should be doing, if they're not doing it, that's all.
Okay, thanks. Your question, please.
And I promised, I'm not picking on you, but it was kind of your language and then also this was regarding the Google case, the right to be forgotten. Right, it's not a great term, but nor is necessarily erasure, because it is just the link that's got. The Vanguardia piece is still there. In fact, if you Google it, it's the second result underneath. You've got news, you've got the Guardian piece, and then there's the PDF from the Vanguardia that started all this. I mean, are we really protecting somebody's right to privacy, the right to have the fact that this guy lost his house back in '98? Or are we just obfuscating it a bit, making it a little bit more difficult to find out? Because that piece of information is still there. I could still go on the internet if I know where the URL is and find it. I could republish it myself now and it would be there. Or save it or email it or whatever. I mean, is this kind of maybe a bit more of a statement act, if you get what I mean, like you're kind of a big show, that this isn't coming out very well, but like a big kind of, we're doing something for this guy who is in an unfortunate situation without actually necessarily doing anything.
Yeah. Your point, and I must say, first blush, it does seem a bit awkward that the webpage on the La Vanguardia stays up, but fewer people can find it because it won't, although she says to come out second.
Search.
It
took me a long time
I
to
don't.
find him on that page.
Okay.
But it is
Okay.
there.
So, but I suppose, I mean, if you think of it offline, I mean, if your family and maybe your friends in your street know that you've got a certain illness, but it's not published in the local paper, your privacy comes by degrees, and questions of necessity and proportionality play a major role in privacy rights. So maybe it's not so strange after all. I do think the practical implications, it is perhaps something of a statement, and quite how it's going to work in practice. And I understand the criticisms which say that that's a very odd outcome, that ordinary people won't be able to find. And of course, I wouldn't certainly not want to get into the situation where people could not find legitimate information about, dodgy or fraudulent traders or whatever, because they've taken it off. So quite how it's going to work in practice is going to be a challenge. But I think it's not, it's only because we're thinking of it in an online context that it seems quite so odd. If you think of it offline, it doesn't seem quite so odd. But it is going to be difficult, which is why we need to cross the I's and dot the T's the other way around in the legislation. And I do hope the member states, including the UK, will be anxious to come to the negotiating table after the elections.
Any other comments? No, okay. Perhaps what I'd like to do, since time's going on, is we've talked about net neutrality a couple of times, and we could move on to that since it's a very hot area, and maybe some other people have some questions on that. So I'd like to rather unfairly ask everyone on the panel to define what they mean by net neutrality.
Oh my God.
To say whether they think it's important or not. Who's going to be brave? No, it's all right. It's okay, I mean, nobody can really define it anyway. I'm just interested in what you think you want to do.
I'm going to cheat then. I'm going to cheat because I've actually got a definition from, which was from, this is not my definition, but it might help, and it sounds good to me. This is from the Save the Internet campaign, one of those lobby groups. And they came up with 3 principles, which I like the sound of. I'm not saying it just seems to make sense. One is the end-to-end principle, which ensures that all points in the network should be able to connect to all other points in the network. The best effort principle, which guarantees that all providers of the internet should make their best effort to deliver traffic from point to point as expeditiously as possible. And the third principle, the innovation without permission principle. Everyone should be able to innovate without permission from any other entity. And I mean, I'm not saying I'm certainly not saying that's it. That's my, but that sounds like quite a good starting point. And I think if we get to I think what would be good is if we can agree very broadly that something like net neutrality is what we want, then we can start looking at the detail of the definition. My feeling is it's probably that way around. What I would say, and the Greens are very keen on this as a crucial element of what could be some kind of bill, even if it's just tidying up exercise in some frameworks. It is really that you have these cases where traffic on the internet can be speeded up, can be slowed down, the movement of content can be adjusted for commercial reasons, for corporate reasons, and something that maybe we haven't spoken about very much, and certainly is a distinctive position of the Greens, is that really the internet is part of the digital commons, and actually is a virtual space, which should as much as possible be open and free and available for creativity, for innovation, and this has the potential to be this hugely important resource for us all globally, collectively. And that might sound a bit aspirational and idealistic, but there's a place for that. And I think the net neutrality idea and the net neutrality principle is something that we should work towards. And something that worries me is when you have these corporate players wanting to work with ISPs in a certain way to adjust that and to change that, and that's something we do really need to resist.
Paul, do you have a favourite definition of net neutrality?
Well, I don't actually, because to me it sounds very vague. On the one hand, you have the technical aspects of it that make it easier to access. But on the other hand, you're looking at regulation of it. I have no idea whatsoever as to the technical advances that can be undertaken to improve everyone's access to the internet, but as in most instances, technology will advance on its own. But certainly, as far as anything else is concerned, and as to access to content, I am a minarchist, that is not an anarchist. I don't believe in a total free-for-all on the internet, and subject to what I was saying before about criminal activity on the internet being prosecuted under the criminal law, that should continue, but really I would like to touch on no regulation at all.
Sarah?
Well, I'm a bit of a brass tacks person, so I'd rather concentrate on what it delivers rather than how it's defined. But I'm happy to sign up to Danny's definition. I think I know a little bit more about it than I did 3 months ago, because I got involved in the Aldi group in the negotiations on the latest telecoms package. And unfortunately, it was shaping up to be a standoff and a logjam in the negotiations between the political groups. And I'm delighted that my Aldi group colleagues, Jens Roeder and Alicia Skara, really took the lead and worked with NGOs, which was a very helpful partnership, to come up with amendments which managed to get support and went through the plenary of the Parliament. So, I mean, it consists of an open internet, which allows not only kind of media pluralism and freedom of expression and access to information, but also low barriers to entry to allow for innovation. Again, where we are geographically, Tech City is very important in this part of the world. And I mean, the wording we got into the position of the Parliament is about bans on blocking or throttling, no discrimination against online content or applications, a duty on regulators to ensure that specialised services can only be provided where there is network capacity to do so, and when those services are not to the detriment of general internet access. So I guess the bottom line is not to have a two-tier internet. I mean, my group is not against specialised services as long as they do not impede general access to the internet. So I guess it depends on here, my knowledge starts to desert me about whether extra capacity can be built, not squeezing other people off, and obviously not. And another thing I think we've got into the regulation is about being able to end a contract if you're not getting the speeds that you were promised, because we all know that that's a major problem. Whoever your internet provider is, we never get the promised speeds, or almost never, so I think that's quite an important thing. So I hope that we'll all make progress after the election. That's another pending legislative dossier that's going to it's a good incentive to get re-elected. These dossiers are waiting to be finalised.
Yeah, I have copious notes of this, but I'm not going to patronise you with reading them out. I just want to say that we had a vote on this in the Parliament, which really concentrated the minds of MEPs, including those who don't understand the technology, and I include myself in that, notwithstanding the inquiry that I've just done. And what I think is this, that there were a lot of MEPs that were afraid of this concept of net neutrality. They were afraid of this, various, scare stories about what it means to have a full and open internet, all traffic being treated equally. They should have been reading your blogs, Glenn, about the microsurveil and, rules being created in Brazil at the moment, and all sorts of developments. And this is my plea, really, because I'm one of those, generationally, not, one of you, not really completely technologically up to speed, but really learning fast. And I think what we learn from people in this room, and if we represent London as we all do, is to really take this issue seriously. And the vote that we just had in the Parliament really concentrated our minds that we have to give you entrepreneurially the most open and free internet to create what you want, right up to the limits that we can, as much freedom as possible, so you can do what you want to do up to the limits. And this is what net neutrality really means, essentially. But where, for example, in Brazil they're trying to create rules, we need to really be aware of that. And so it's a conference now taking place, I think, in Brazil.
It's happened already. It's happened already. They passed the basic democracy.
We need to be really aware of what those rules are. And I think the kind of clunking way that some of us approach that net neutrality vote was an illustration of how early in the debate all of this is. And I think that's just all I want to say about net neutrality. That is, people might be thinking they're getting bored of it already, but it's really important. And I think for this area, in this room, we need to be aware that this is the critical issue, to give you that freedom, entrepreneurial freedom. And I think our politicians need to be educated more about it. And I've got loads of definitions here I can give you, but I find it very complex. But for London, for Hoxton, for Old Street, it just basically means some entrepreneurial freedom on the net, openness and freedom. But we've talked about the law today as well. But we can't be clunking about it. We need to be sophisticated about it. And that vote, if you saw it in the Parliament, was basically the whole Parliament needs to be more well educated about it. In the Trade Committee, it was not well informed, and then it went through to the whole Parliament. And again, I think we need to move on from that in a more sophisticated way.
Thank you. In fact, entrepreneurial freedom is a great lead into what I'm afraid is going to have to be our last subject, because we've only got 10 more minutes. That's how much I'd like to go on, which is copyright, because I know a lot of people in this room care about copyright. And it's the lack of the kind of entrepreneurial freedoms that are found elsewhere, notably in the States, which I think has led to a lot of companies feeling constrained in this country. So my last big question I'd like to ask the panel is, how do you think we should update copyright to make it fit for the digital age, to give people that entrepreneurial freedom, and to be fair to all the people involved, which includes the end users? And I mention those specifically because hitherto the end users have really just got what they've been given. But I think now end users are much more active and have a much more real sense of what they want from copyright, and they're not getting that as we see copyright term extended and extended and extended. This is actually taking away from that digital commons that we were hearing about before. It's actually taking away from the public. So how can we start to give back to the public in the realm of copyright? Danny, perhaps you'd like to talk about your commons in the context of copyright?
Yeah, certainly I think we need to look at new models. Well, some of them aren't that new anymore, but they've been around for a while. The models, Creative Commons models, copyleft models, models which preserve the open formats that exist, and look at ways of ensuring that they're protected, they're enhanced, and that these can potentially become the norm. I mean, one of the things that the Greens want, certainly in relation to software, and I appreciate how these open models manifest in different areas will be different, but certainly in relation to software, that actually there's an opportunity for institutions to positively endorse and promote open source modelling for the software upgrades they do, and some institutions in the UK are doing that. And I think that provides an opportunity and an opening for innovation as well. And working more closely with innovators, actually, and finding out more and understanding more about what is holding people back in those terms, what they would like to try and do, but what they're unable to do because of the legal structure, the longer-standing legal copyright structures that currently exist, and be open to those new models. I think that's the most important thing, really, for there to be a change, for there to be a shift. And certainly keeping those models going as they are, I don't really think is an option. That's not to say abandon all forms of copyright. I'm not saying that. I'm just saying that the field needs to be opened up to these other models too.
Paul, what's your position on copyright and entrepreneurial freedoms in that context?
Well, certainly I'm against any extension of copyright periods, which are largely being pushed by corporate interests, and it's frankly too bad if Cliff Richard finds that his earliest songs are now available free of charge on the internet. When it comes to stolen items, again, I think the market probably has the answer, because fewer people are using, as I understand it, file sharing websites like the Pirate Bay now, because you have cheap, easily accessible and best of all good quality alternatives in the likes of Netflix and that, Amazon Prime, etc. So as long as something's relatively cheaply available, I think that people will buy it, but you're never going to get rid of it, copyright theft in its entirety. As far as the more technical aspects are concerned, well, unfortunately, I think that bigger industries in particular are going to carry on ripping off the small guy. When it comes to code and things, was far above my head. You're never going to get over that, and really, I think the best way of dealing with it is through the courts as now, and that applies to patents and trademarks as well.
Sarah?
I do find copyright very difficult to get my head around. I believe in principle in the right to ownership of creative production. And again, there's a lot of small entrepreneurs who need that kind of protection. But I think it's got to not be heavy-handed. I rather think of an equivalent with sort of money laundering laws, which end up bugging every individual. You have to take, about 5 documents to the bank. And the big guys who are laundering billions of pounds through the London financial markets don't get caught. So, something that's really heavy-handed and inflexible and impacts on every individual in irritating ways seems to me self-defeating. But I want to address serious copyright theft. I want people to be out, even Cliff Richard up to a point. But I think there's a lot of, modest musicians, for instance, who live off copyright returns, who didn't make much from live performances and live off copyright. I must say I didn't agree with the extension to 70 years, I think, passing. That seemed to me...
Life plus 70 years.
Life plus 70 years, God. I can remember someone explaining to me that it should, it's important that it should go to the heirs, but I don't actually think that's right. I think it should go to someone in their lifetime, but I don't think necessarily the heirs should inherit a stream of copyright levies or whatever. So, I don't know the details. I think there's a live debate in the UK in Westminster Parliament at the moment, but please don't press me on the details because I don't know them. But I think somehow we seem to have got into an awful bind. But I do, in principle, support intellectual property. I think that is important. It's not just tangible things that should be able to be owned. But we seem to have got ourselves into a really outdated, inflexible, and a model that doesn't command broad support. So it's clear that it does need reform.
Lord, I started with you, so I'll finish with you.
Yeah, I want to support legislation that expands the scope of or duration of copyright or any similar rights. And I think in relation to the internet and so on, we have to be very careful how we treat copyright. And I think my party is in the Parliament because we've tried to struggle with this and has tried to do this. So that's my position. Of course, there's intellectual copyright and intellectual ownership, but we have to be very careful about how this proceeds in the future, so I wouldn't support any extension of copyright. I think that's our watch roadmap. Okay.
I can't hear about that.
So I wouldn't support any extension of copyright or any legislation that supports it.
Okay, so I'm really sorry.
May I add just one other thing which just occurred to me?
Yeah.
I was told the other day, actually, I've completely forgotten about this in my answer. Everybody apparently, although I still prefer vinyl myself, is downloading things off the internet, is downloading music off the internet. And apparently, and you'll correct me if I'm wrong, those music files that you have downloaded cannot be passed on to your heirs and successors.
Yeah.
That is a disgrace in my opinion. You ought to be able to do that. Now, whether they wipe them, if they're digital files, I mean, if you're talking records, I very much hope that my grandchildren are going to play my punk rock LPs to death. The chances are that they'll probably take them down to the charity shop. But that is their option, and that is something you can't do at the moment, and I'd very much like to see that change.
I agree with that. One thing I agree with.
Okay, that's a great note to finish on, So I'm sorry we haven't got time to discuss many others. I think we've covered an incredibly wide range this evening. I'd like to thank the speakers for being put on the spot and being asked unfair questions like the definition of net neutrality. But I thought they all covered brilliantly, so I'd like to ask you to join me in thanking them for